Welcome back to a new post today. Today, let's discuss the most important issues for polity and governance of the week gone by for August 2017 to 23rd. That's last week. So, the very first issue is about now the unhappiness about the dysfunction of the legislature, that is the parliament. And if looking at the working of the parliament, there has been very less productivity. That's because of the conflict between the government and the opposition demanding a discussion on the special intensive revision of the Bihar electoral rolls. And therefore, with the demand of a debate on the SIR, which did not happen, this led to the legislative business being carried out very little or no debate at all in a session with 21 sittings spread across 32 days. That's from July 21st to August 23rd. 15 bills were passed according to the PRS Legislative Research Analysis. Lok Sabha functioned only for 29% of its scheduled time and Rajya Sabha for 34%, the lowest functioning ever seen during the 18th Lok Sabha. Two-thirds of the planned time was launched due to repeated adjournments. In the lower house, only 8% of the questions were received on oral reply, and while it was only 5% in the upper house. On 12 days in the Rajya Sabha and on 7 days in the Lok Sabha, no questions were answered at all orally. Over 21 days, and question R, an instrument of executive accountability, has been rendered totally ineffective. The dysfunction of the legislatures is linked with the concentration of power in the chief executive, that's the Prime Minister, the centre, and the Chief Minister. Now, according to an annual review of the state laws 2024 by BRS Legislative Research, the state assemblies met for an average of 20 days in 2024, down from 28 days in 2017. Larger states like Uttar Pradesh, Madhya Pradesh recorded only 16 sittings days, and while Odisha and Kerala 42 and 38. More than half of the bills were passed on the same day with little or no debate at all. 8 assemblies do not have a deputy speaker, and Lok Sabha does not have a deputy speaker since June 2019. The parliamentary committees have been a platform of deliberation, but as of recently, it has become a platform of it has become vulnerable to partisanship, and this is about inaction of the legislature. And the starting point, however, can be a consensus between the opposition party and the ruling government, especially with taking the opposition to confidence by appointing a deputy speaker of the Lok Sabha that has been pending since 2019. Therefore, the ball lies in the court of the executive, that's at the centre, that's the Prime Minister, and at the state, the Chief Minister, to ensure productive functioning of the legislatures. And on this ground, the importance of the speaker plays a lot, especially during conducting of sittings. The speaker is the head of the house, and they maintain discipline, decorum, and they are the spokesperson of the house, especially the lower house, of which they are presiding officer. They interpret the rules, constitution, and protect the rights and the privileges of the members. That's the most important. Now, marking 100th anniversary of the freedom fighter Vittal Bhai Patel, who has been the first Indian Speaker of the Central Legislative Assembly, then at that time in 1921 called as President. The All India Speakers Conference was organized in Delhi Legislative Assembly to commemorate the centenary anniversary of the freedom fighter Vittal Bhai Patel. Now, he laid the foundation for India's legislative traditions, and also which goes on to strengthen India's democracy even today, and he established numerous traditions that continue to guide all of us in the legislative functions, especially with regard to the role of the speaker. During Vittal Bhai's tenure, the legislative department and the legislative assembly secretariat were established at the centre and the states, giving more weightage and power to the legislative assembly. The conference was attended by the speakers and deputy speakers of all the states and the union territories who have legislative assemblies, as well as the chairman and the vice chairpersons of the legislative council. The post of the speaker and the deputy speaker originated in 1921 under the Government of India Act 1919, that's the Montague-Chelmsford reforms. Speaker and deputy speaker until 1947 were called president and deputy president respectively. The Supreme Court now has modified its harsh order on the release of stray dogs. So the earlier directive had provoked a strong opposition from animal rights activists, welfare organization and public figures who stressed that the Delhi region lacked proper infrastructure to take care of the dogs. As well, the Supreme Court modified its earlier directive requiring the civic authorities in Delhi and 4 adjoining districts to capture all the stray dogs, confine them in shelters within 6 to 8 weeks without releasing them. And the court, terming the August 11 order too harsh, directed that the animals undergo sterilization, deworming, immunization before being left free in the localities where they were captured. The 3-judge bench noted that the earlier mandate was intended to protect the citizens, especially by attacks of aggressive dogs who are infected by rabies, and however the absolute prohibition on their release could run contrary to the animal birth control rules and also the Prevention of Cruelty of Animal Act 1960. The court clarified that it would not apply the dogs, however, the release of the dogs would not apply to those who are infected with rabies and those who have aggressive behavior. The court directed the municipal authorities to set up dedicated feeding zones in every ward to ensure how no inconvenience is caused due to feeding of stray dogs in the public spaces, and noted that the measure was necessitated by reports of untoward incidents causing unregulated feeding, which had created great difficulties, especially for the common man walking on the streets. And the bench they further directed the civic authorities to also set up a dedicated helpline reporting violations, adding that such complaints should be dealt with appropriate manner. So therefore, reversing back its earlier order on the stray dogs, the Supreme Court. And the next one is now Great Nicobar Project, once again as gain highlight. So a tribal representative body which is called the Great Nicobar Tribal Council. Now this has come to fore with saying that it has not given its approval for the project, and the forest and the rights of the tribals have not been protected and respected under the Forest Rights Act. The Andaman and Nicobar Islands administration made a false representation, it says, to the centre, claiming that the rights of the tribal people under the Forest Right Acts have been identified and settled, which eventually led to clearance for the Great Nicobar Island Development Project, which will see a proposed transshipment port, an airport, a power plant and a township. Now, local tribes people raise concerns of the diversion of forest, especially because they are tribes, and the project and the vulnerabilities of this groups in this area. After taking charge, the Ministry of recently the Ministry of Tribal Affairs has said that all the interests of the tribes in the Great Nicobar region have been taken into confidence. However, the council has now said that nothing of this sort has been done. The council is a key representative bodies of the Nicobarese tribes on the island and has been interacting with the administration on various issues. Now, according to the forest diversion certificate under the FRA issued in 2022, the administration said that the complete process for identification and settlement of the rights under the Forest Right Act has been carried out. But however, the council says that nothing of this has been done. Let me tell you that there are 2 acts under which the tribal rights are protected. One is the Forest Rights Act and one is the Protection of the Aboriginal Tribes Act of 1956. While the Protection of Aboriginal Tribes Act 1956 gives the administrator of the island full authority to divert the forest land, the Forest Right Act prevents such diversion and allows such diversion only when the rights of the tribals are settled, and that too with the consent of the Gram Sabha. Now, it is not clear whether the tribal land is being diverted under the Forest Rights Act or the Protection of Forest Aboriginal Tribal Act of 1956. However, if it is done under FRA, the Tribal Council says that it's not given permission for any diversion of land, and therefore this matter has to be looked into. UGC now is bringing back ancient Indian knowledge into focus. It says it is doing so under the learning outcomes based curriculum framework under the new education policy of 2020. UGC has released a draft curriculum for anthropology, chemistry, commerce, economics, geography, home science, mathematics, physical education, political science. It revives traditional Indian knowledge systems. For example, in mathematics for undergrads, the curriculum features ancient Indian concepts like sutra-based arithmetic, algebra, kala, gana, and Ganana and Bharatiya Innovations Geometry from Sulva Sutra of the Vedic period. The council has invited stakeholder feedback on the draft curriculum, and many states have also criticized, and some of them have raised questions about the need for learning ancient wisdom and now during these modern times, as we have developed much more than them. The LOCF, or the Learning Outcomes Based Curriculum, is clearly on clearly defined skills and knowledge is mentioned in the National Education Policy. It emphasizes on skills and knowledge. Students have to gain completion of the skills during the completion of the course. Under this learning outcomes based curriculum framework, courses are categorized into major, minor, skill, value added courses. In a notification on 20th August this month, the UGC said the draft will serve as a model curriculum to encourage flexibility and innovation in design and symbol, and also protect the ancient Indian knowledge systems. It recommended teaching of history, development of Bharatiya Bijaganita or Indian algebra, division of polynomials using Paravartya Yogayat Sutra, a traditional Vedic mathematic learning technique, meaning transpose and apply. SC now has protected the rights of journalists under free speech and has restrained Assam police from taking action against the journalist under the section 152 of BNS. The court protected the journalists from sedition charges, highlighting concerns of potentiality of abuse and misuse of section 152 of the BNS. A bench comprising Jogmalia Bagchi and Surya Kant now has passed an order on a plea filed by FIJ, which owns the buyer, along with Varadarajan, who is one of the accused. Supreme Court protected the arrest of the Wires. It's a magazine and online news platform founded by Siddharth Varadarajan and consulting editor Karan Thapar in connection with the FIR filed by Assam police against a new article in the Wire. The bench said that the plea was filed by Foundation of Independent Journalism, which owns the Wire, along with Varadarajan. On August 12th, the top court protected both of them from taking coercive action against them with regard to FIR filed on their comments on Operation Sindoor. And the first FIR was filed in May 9th and later on again in August as well. They have filed the FIR under section 152 of Bharatiya Nyaya Sanhita, which says acts endangering sovereignty, unity and integrity of India. The FIR listed 14 interviews and articles as against sovereignty and integrity of India, and there was no further action taken later after the Supreme Court's directives till August 12th. Supreme Court has time and again said that the power to arrest and the reason for arrest has to be used very judiciously. So just because we can arrest anybody, we cannot use the power of arrest. However, arresting is important when a person has definitely committed a crime, and that is unlawful under the Indian laws. Using the power and for the correct reason, and just using the power because you have the power to do so is quite different. That was what the Supreme Court has said. Now, the IT Act of 2025 got President Draupadi Murmu's assent. So, a bill at the center can become an act or a law only after the President's assent. And very recently, the President's veto power with regard to state bills has been gone to a reference bench, that is a constitution bench, hearing a case in matter of a reference by President Draupadi Murmu under Article 143 of the Constitution. The new law, that's the IT Act 2025, removes redundant provisions and archaic language and reduces the number of sections from 819 in the Income Tax Act of 1961 to 536 in the number of chapters from 43 to 23. President Draupadi Murmu has given an assent to the Income Tax Act of 2025, which will replace the archaic Income Tax 1961. It will come into effect from the next financial year, that's April 1st, 2026. And the new act will have simple laws and reduce wordage in the legislation, which will make it very easy to understand. It has received the President's assent on August 21st, 2025. The Landmark Reforms Act replaces 1961 in a simpler, transparent, compliance-friendly direct tax regime. And a report by the ADR, which is called as the Association of Democratic Reforms, it's an NGO. The report says that 40% of the chief ministers face criminal cases. Now, you have to know the issue first of all, and this is with regard to the Government of India passing bills that will now ouster ministers, that's Prime Minister, Chief Minister, and also CM. So the Government of India has passed the Government of Union Territories Bill 2025, Constitution 130th Amendment Bill 2025, Jammu and Kashmir Reorganization Amendment Bill 2025, seeking to remove the Prime Minister, Chief Minister of a state or a union territory when arrested and detained on serious criminal charges for 30 days in a row. If any one of them is arrested and detained, let me tell you, not convicted but arrested or detained in custody for 30 consecutive days for offences that attract a jail term of 5 years, they will lose their job on the 31st day. The 130th Amendment seeks to make changes in Articles 75 and 164, and after the criticism of the opposition that has been sent to the Joint Committee of the Parliament, it says that a minister who for a period of 30 consecutive days during holding office is arrested and detained in custody on allegation of committing an offence under any law of the time being in force, which is punishable with an imprisonment of a term of 5 years or more, shall be removed from his office by the President on the advice of the Prime Minister to be tendered on 31st day after being taken under custody, provided that if the advice of the Prime Minister for the removal of the minister is not tendered the 31st day, the minister shall cease to be a minister from on the 31st day thereafter. And the opposition party have called the bill draconian, accusing the BJP of going back to a police state and in medieval times where the king could remove anyone whomever he wanted to do. And also with regard to unclarity and of the bills, there is a provision of misuse of them by the centre especially. And apart from this, yes, on the basis of this, we have a report by ADR saying that 40 chief ministers have criminal cases against them. The report comes as the government has brought these 3 bills seeking to remove the Prime Minister, the Chief Minister, and the ministers if they are arrested and detained for 30 days on criminal charges. Of the 30 ministers, 12 of them or 40% declared criminal cases against them in their affidavit. These include the Telangana CM Revanth Reddy declaring 89 cases against him, the highest Tamil Nadu Chief Minister Stalin declaring 47, Andhra Pradesh Chandrababu Naidu 19, Siddaramaiah 13, Hemant Soren 5 cases, Maharashtra and Himachal Pradesh Chief Ministers have declared 4 each, Kerala Pinarayi Vijayan 2 and Bhagwat Mann 1. The remote comes as the government has brought these 3 bills, and it says that 10 or 33% of the chief ministers have declared serious criminal cases against them with regard to attempt to murder, kidnapping, bribery, criminal intimidation against them, and with their own self-sworn affidavits. And apart from this, you have Sudarshan Reddy, the opposition candidate for the Vice President nomination, filing his papers to the returning officer for the Vice President, that's the Rajya Sabha Secretary General. As many as 160 MPs have signed as proposers and seconders. The Electoral College for the Vice President includes both the members of the Lok Sabha and the Rajya Sabha, and none of the members from the State Legislative Assembly or the Legislative Council and the Union Territories as well. The effective strength of the Electoral College is 789 and the majority mark is 391. That is the number of votes that the candidate who has to win needs to get. The ruling NDA has fielded CP Radhakrishnan, and the ruling party enjoys the support of at least 422 members above the majority mark, and non-India bloc parties such as YSRCP have already announced their support to Radhakrishnan. The prospective vice president candidate has to file his nominated papers with 20 electors as subscribers and 20 electors as proposers. The candidate has to make a security deposit of 15,000, which will be forfeited if he loses the election. And opposition party have called to bring a bill for reservation of SC, ST and OBC in the private education institutions, and this has been recommended by a Parliamentary Standing Committee on Education, which is chaired by Digvijay Singh. They also brought into highlight Article 15, Clause 5 of the Constitution introduced by the UPA government under Prime Ministership of Dr. Manmohan Singh, late Dr. Manmohan Singh, in 2006 through the 93rd Amendment Act, which empowers the government to mandate for reservation for SC, ST, OBC in private higher education institutions. In May 2014, the Supreme Court in Primati Education Cultural Trust versus Union of India upheld the validity of Article 15(5), affirming reservations are permissible in such institutions. And the Parliamentary Committee on Education has highlighted the low amount of representation of the marginalized communities, SC, ST, OBCs in these institutions. Article 15(5) says that the state can make special provisions by law for advancement of socially and educationally backward classes of citizens, or for SC and ST as with regard to the admission in educational institutions, including private educational institutions, whether aided or unaided, other than minority educational institutions. So this is what Article 15 Clause 5 says. And now we have the last issue coming up is the Constitution Bench that is formed by the Chief Justice of India. It is given, the reference given by Draupadi Murmu. President Draupadi Murmu is being heard by a Constitution Bench headed by B.R. Gawai, and this is a Constitution Bench that the Supreme Court forms, which consists of at least 5 judges, and they can decide on any issue of substantial question of law or interpretation of the Constitution for the purpose of, and also for the hearing of any reference made by the President under Article 143. The provision has been mandated by Article 145 of the Constitution. All matters related to the amendment of the Act of the Indian Parliament are referred to the Constitution Bench of the Supreme Court. The Chief Justice has the power to constitute the Constitution Bench and refer cases to it. Constitution benches have decided one of the best known cases in the history of the Indian government, and many example, the Kesavananda Bharti case versus State of Kerala, which decided the basic structure doctrine at the largest ever Constitution Bench consisting of 13 judges. And there have been many other cases like A.K. Gopalan versus State of Madras, etc. So these are the most important issues I thought I should be discussing with you all with regard to polity and governance for the week gone by from 17th to 23rd. If you did, please do like, share and subscribe, and don't forget to comment at the end of the video. I shall see you in my new post. Until then, it's very happy learning.